thrilled to have so many people here today interested in startups at the university. And as Shane mentioned, it is kind of a difficult path to do a startup here. So I just want to stress that NUtech, even though we're a small team, we've got 9 people, we're really willing to help you out and try to get over some of the hurdles that you're going to encounter. So thank you for coming today. I was asked to talk today about intellectual property for startups, and we're fortunate enough to have Molly from the Patent Office who's going to be talking at 4 o'clock about IP as well. So I'm not going to cover some of the in-depth issues with patent law and changes, what you can and can't get a patent on. I'm not going to talk about necessarily why you should care about intellectual property for your startup, but I'm going to try to address 5 main points that I think are really critical for you if you do have an interest in doing a startup at the university. So to begin, I'm going to talk about just briefly the different types of intellectual property that are important for a startup. I'm going to go over the difference between ownership and, on the other hand, inventorship or creatorship. And Shane addressed that a little bit, but sometimes it can be a little complicated. I'm going to talk about the commercialization process at universities and particularly at NUtech Ventures. And then I'm going to talk a little bit about what the expectations are for a partner when you do go to commercializing technology. And that could be an industry partner or your startup. And then lastly, I'm going to talk a little bit about the licensing aspects of intellectual property and how that relates to your startup. So to begin, though, I want to start off by just telling you a story about an alarm clock. And I didn't realize that alarm clock technology was really stagnant. It was in 1950 when GE developed the snooze button. And then after that, there was no innovation around alarm clocks. And how many of you are chronic snoozers in the mornings? Probably a few, yeah. So this is Taki. Has anybody seen this alarm clock before? A couple of engineers, okay. So this is the runaway alarm clock, and it's fantastic. I thought for sure when I bought this it was going to change my life. Basically what it does is it sits on your nightstand, and when it goes off, it jumps onto the floor, rolls around, and you have to chase it and shut it off, and it basically makes you get out of bed again. So this was invented by a woman, Gloria Nanda from MIT. She was doing a graduate project in the media lab there. And she was a snoozer. She missed all her morning classes. And she said, well, I'm going to try and invent an alarm clock. So she did. She came up with different microprocessors and algorithms to make this work, to make it stable so that when it does roll off of your nightstand, it doesn't break. And then the patterns that it moves around in are random so that it's, you can't learn it's going to go under the bed. And I never find it. So it mixes it up a bit. So Gloria invented this. She disclosed her technology to the patent office, the commercialization office at MIT, and then they put it through their assessment process. So they asked some, real basic questions. Number one, is this technology something that we could patent? Is there something like it in the marketplace already? If we did file for a patent, would we be able to recover our money that we spent? So they decided, yeah, this is actually something we could patent, and so they moved forward with it. And then Nanda went on to publish this on her blog, and it went viral. So a bunch of techie blogs published it. She was asked to talk on Good Morning America, and people started asking her, when can we buy this? When is it going to go on the market? And she said, whoa. At that time, it was a prototype, and she tried to make it sort of this zoomorphic-looking kitty thing, and it was fuzzy, and so it was a long way, basically, before she was going to be able to sell the product. But she started thinking, wow, I could actually start a company around this and be successful. So at that point, she went back to MIT and their tech transfer office and worked out a negotiation with them. She wanted to do a startup, so she was going to have to take a license because, as Shane mentioned earlier, she didn't actually own the technology. She was the inventor, not the owner. So she ended up taking a license. She got the exclusive rights to be able to make and sell this in the marketplace. And in 2008, she, I think, made $1.5 million. And she's been pretty successful with it. She's now trying to pivot a little bit and find new technologies and new products so she can continue to make her life out of this. So that is coffee. I just want to go back. I think it sort of exemplifies all 5 of these areas though. So the type of intellectual property inside of this, so there's probably not less than 20 types of intellectual property in this one product. There's obviously lots of trademarks. Clocky, she has other products, Tiki and Taki, those are trademarked. Her company name is trademarked. The design of this sleeve is trademarked. The design of the interface is trademarked. And then there's patented technology within this, and then copyrighted protection as well on, you know, all of their website information about explaining this and the software that's inside of this copy. I talked a little bit about the commercialization process and how Nanda went to the office and had to do this negotiation because she did own the technology. The expectations from MIT and her taking this out on her own, she had to justify that she could actually be profitable on this and at some point pay back the patent costs that the university had expended on patenting this. And then the licensing process. And we're going to go through each of these in a little bit more depth. So types of intellectual property. We have kind of a diverse crowd here today, so I'm not going to go very in depth on any of these, but I just want to sort of spell out the different types of intellectual property that you would probably be, would be important for you in starting a company. So we have patent protection. This makes up the bulk of the university's intellectual property portfolio. It's also the most time-consuming and expensive, as most of you know. You have to have an idea that is new, useful, and not obvious. So it hasn't been in the marketplace before, and there isn't something like it that would make somebody say, oh, well, this would be obvious to me. Patents can cost anywhere upward of $20,000 to obtain, and that's for U.S. rights. Many of you are familiar with this. Patents are territorial in nature, so if you want to put your product in another country, you have to obtain patent rights in other countries as well. So you can imagine the costs can get pretty high for patent protection. It also offers probably the greatest protection that you can get on products. Copyright and trademark, though, are also really important, but much easier to obtain. Copyright protection, by virtue of creation, exists automatically. There's some benefit to registering a formal copyright. It allows you to have, when you're litigating for your rights on your copyright, you get statutory, some statutory rights that are included in that. You can get attorney's fees if you sue somebody for infringement. So it's beneficial to file for a formal copyright, and it's really inexpensive. I think it's $85 today to do so. So that's something we're willing to help you with as well. Trademarks are relatively inexpensive too. It costs between $200 and $300 to file a formal trademark. And this is, you know, protecting your brand, so the Clocky brand. You don't necessarily have to file for formal trademark protection to be protected, but it's very wise. So if you start using something in commerce, you automatically get some protection from doing that. But it's wiser to just go ahead and file your trademark. That way it also gives notice to other companies that, you know, I'm claiming Clocky or Taki. And so if you come along and try to use that same name, it's going to cause confusion, and I'm going to have the rights to it. So ownership of intellectual property. This has become an issue for us that we get a lot of questions on. So I just want to walk through this a little bit. And for those of you who are familiar with the Board of Regents policy, you can find all of this information in 4.4.1 and 4.4.2 if you care to go there and read about it. But essentially, I always think of it as sort of follow the dollars. So who is supporting you at the time of your creation of your invention? And when you work for the university, by virtue of your employment contract, like Shane mentioned, the university owns all of the rights to your intellectual property that you create. And so if you use substantial university resources, there's really no doubt about that. So if you're a faculty member of the university, paying your salary, you're using, you know, fancy equipment in your laboratory, it's definitely going to be owned by the university. On the flip side, if you're doing traditional works of scholarship, those rights vest with you, the creator. So any of your publications, your manuscripts, your theses, books, curriculum that you're using maybe in teaching a class, those all remain with you, the creator. Where it gets more complicated is when we've got additional sources of funding that go into a particular invention. So oftentimes it's not just the university that's supporting your research, you're getting outside funding. And it might be from another institution, so you might be collaborating with another university. It might be from an industry partner, federal agencies, and then also the commodity boards. And in 1980, so on the note of the federal agencies, in 1980 there was an act passed called the Bayh-Dole Act. And essentially it gave universities the right to retain title to inventions that are developed at the university using federal funds. Before that, the federal agencies retained the rights, and a lot of the inventions didn't go anywhere. They were not commercialized. So this is something that gives the universities the rights to license and develop technologies, but we have a lot of obligations that we have to comply with for the federal agencies. So it's always really important to, when you're filling out disclosure forms, if you have a technology or an idea, to make sure that you're confirming the source of funds, because this can get really complicated if you don't. And then with industry partners, I mean, almost always they're going to want rights to your invention if it's something that they funded. Commodity boards as well, they generally will take a royalty on any profits that are made from an invention that they funded. And then other institutions, oftentimes we will work with other institutions to do an interinstitutional agreement. And basically the way that works is we decide on which entity is going to take lead on developing, commercializing, and patenting the technology, and then we sort of split up the costs and the rights and the royalties. And then the last category is independent work. So this is where what you do in your day job is very, very different from something you invent. And that's something else that you invent then is an independent work and it's yours. So the ownership rests with the inventor. I think of if you're an engineer and you're working on electronics, but then in your side time you grew up on a farm or something, you come up with a feed for a particular pig feed or something. That's very different, right? So there would be no question there as to whether or not that was university owned. It gets tricky if it's more aligned with what you do in your research job. So that's something you just have to be willing to validate that it's separate. And then as part of the school, university is the owner of your work, we want to make sure that there's incentive for you to invent things here. And so we've set up, and all universities have this, there's a royalty distribution that we have in place. And basically the way it works is any profits that are derived from an invention after expenses, so we want to make sure that we can recover patent expenses because they're very costly often. But after that, all of the profits get distributed then according to this chart. Inventors, creators get 33%, and then a chunk of it, 20% goes back to the departments. And if you have more than one inventor, the total piece is still 33%. So we kind of leave that up to you to figure out, what contribution each inventor had. If it's 2 and you think it's 50-50, you trust that, that's correct. If it's 5 people, you need to sort of work amongst yourselves to figure out what you think is a fair distribution of that. And we have a form that can help you with that, but we kind of leave that in your courts. And then just a note about inventors. Inventors is a legally defined concept, so very different than ownership and very different than authorship. And it's not really a fair definition. And so I'll give you a couple of examples. I might be a faculty and come up with this brilliant idea, and then have 10 graduate students in my lab follow my protocol to help me sort of prove out that my idea is correct. If they do that, you might be doing time assays overnight, so you're working lots of hours, but you haven't actually contributed to the idea or the conception. The students aren't, unfortunately, inventors in my case. On the flip side, I might be a graduate student in a research lab, and I'm working on a project with my PI, but I come up with this idea that's not something we've talked about, not something we've worked on, and I do the experiments, and I figure out that it actually works. The graduate student might be an inventor, and the PI might not be. So I always think of it as being a sort of unfair, inventorship isn't really that fair. But that is the way the Patent Office examines it. And if we get that wrong, it can be sort of critical for your intellectual property. And if somebody comes along at some point in the future and tries to invalidate your patent, that can be an area that could cause your patent to be unenforceable. So we just always try to make sure and get that right. It's hard to think of it different than authorship, where there's a little bit of leeway in inventorship cases. And then the rest of the time, I'm just going to talk a bit about the commercialization process and how it works at NUtech. How many people here have submitted disclosures to NUtech before? Okay, so maybe about half, but quite a few haven't. So I just want to walk through this process, and then I'll touch points on where it would make a difference for doing a startup company versus not. So you get an invention, you come up with an idea, you create something, and you want to talk to NUtech about it. You go to our website, we have a number of different disclosure forms available that you can fill out. There's a general one, there's a different one for biologics, there's a different one for software or apps. You submit that to our office, and then we do some background information on the funding sources. We have a funding memo put together, and we just try to get a general sense of the technology before we meet with you. Then our tech manager team will set up a meeting to talk with you. And basically they want to figure out if, number one, we understand the invention correctly as you believe it to be, but even more importantly, to try and ascertain what your vision is for this technology. Do you see it in a particular application? Do you have a commercial partner already that you're thinking about? Do you want to do a startup? Is that feasible? So we're going to sit down, have a meeting with you, gather some information, collect the facts. Then we're going to take it back to the office and sit at our computers and do a bunch of research. And we have a great team of commercialization analysts, graduate students from various departments that help us out doing patentability assessments, so trying to determine if this is something we can actually invest in, and then market data as well. So we want to know, is this viable? Is there a market for this? Like Shane was saying, can you actually make a profit? Can you make more than you spend on this? So that sort of fits into our general scheme of commercialization. And at any point, we may make the decision to not pursue something. And it's generally a business decision that we have to make there. NUtech is very fortunate in that we have a lot of support from the university, and we have a budget to do patenting and these sorts of things. But we take that pretty seriously because it's a finite amount of money, and we can only invest in certain technologies. So sometimes there's, you could get a patent, but the claims would be really narrow. Sometimes it's a very competitive field. Sometimes we just can't figure out where this technology would fit and who would buy it. Sometimes we can't figure out who the partner would be. So there's lots of different reasons why we may end up not pursuing the technology. We hope that you never take that personal. It's not against your research. We think you're doing fantastic research. And we hope that you disclose again and that the next time the outcome is different. But oftentimes we'll move forward with something and we'll see a business case for it and we'll see that it can be patentable. So we'll go ahead and expend the resources. We work with outside counsel to try and draft the best patents and give the best protection that we can. We work with you on that point and try to get your input as much as possible without being too annoying. If it's a copyright trademark issue, we'll work with you to give those protections if you think that makes sense. And then when it gets to the point of marketing and licensing, and it's something that you want to do a startup around, we're going to just talk with you about what that would look like, how it would be a viable business model. We're going to ask you about what your team would look like. Shane was saying the team is so important. So can we help you in trying to find a CEO? Can we help you in trying to find some technical people to help the company in the early stages? Can we help you get in touch with the folks here that deal with conflict of interest? And you're going to hear from Sarah later talk about that, so stay tuned. But we're here, again, like I said earlier, we're here to help you try to navigate some of these hurdles. So if you do want to do a startup company, we're going to have some expectations from you. And this is really pretty similar to what we would expect out of any industry partner that we align with. So we want to know, is this viable? Is this something that you think can actually make money at the end of the day, that people are going to business justification, as I mentioned. What do the financials look like? What is the path to development? Where are you going to have this manufactured? How much money is it going to take? All kinds of questions that we're going to work with you on here. And then repayment of patent costs. This is something we almost always ask in our license agreements, and in the industry they generally pay us back right away for any costs that we put into your patent portfolio. With startups, we understand that it's going to be rough in the beginning, so we try to spread this out as much as we can. And we try to do what I think is a pretty favorable deal with faculty to getting started, so that you're not killed in the first couple of years that you're trying to get yourself up and running.
Can you tell us how you figured your IP protection costs?
How I
Because
figured.
it's never been clear to me how NUtech comes up with what IP protection amount is. So in other words, how many of the dinners that I've gone to the lawyers with, is that part of the cost?
Oh. So the patent costs are strictly the costs that we pay to the attorneys
That you
for.
pay the patent office? None of the fringe stuff?
No. So we actually pay the attorneys that we work with, and they pay the patent office. So all of the costs that we ask you to repay for your startups are, they're items, they're invoiced from the attorneys. So the dinners with the attorneys are usually on the attorneys. Those would account against you. So sometimes we do expend resources on marketing.
So on any of my patents, can I request a patent cost?
Yeah,
I can tell you what it costs, yeah.
So can I get an itemized billing and what it costs?
Yeah, you know, if it's not something we routinely do because we've got a lot of other things that would be, with all due respect, and it's a lot higher priority than that. But we can generate those numbers pretty reasonably easily. It depends how far back. I mean, you're not paying anything back right now, I don't think, are you? We don't have any licenses that demand repayment right now. And we can give you a ballpark.
It's always seemed to me rather vague with respect to what that patent cost really means.
It's an accounting. It's accounting.
In the future, that patent cost needs to be nailed down so that it's transparent to the faculty member what that can be charged at that time.
For our startups, we know those numbers. We know those numbers exactly, and they're itemized for startup companies.
As a faculty member, we reimburse patent costs. It's exactly that. We get a copy, literally a copy of the invoices from the patent company associated with it. It's as straightforward and unambiguous as I can imagine.
So like in the case of a startup, you may have intellectual property that you create after the fact in your startup, and all of that gets directly billed from the to you, your startup. Right? So that's different. We don't push that number with dinners and those kinds of things. We try to be as fiscally responsible and financially responsible as we can. Okay, so a little bit just about the licensing of intellectual property if you're going to do a startup. People are always wondering how this actually works. So the university owns your intellectual property, and you take a license then to do a startup with your invention. There's a thing called a standstill agreement, and this is a no-cost to you option if a startup is something you're interested in. So basically what it does is it gives you a set amount of time, and usually it's 6 months, sometimes a little bit longer, depending. But it gives you an opportunity to really flesh out what that business would look like. And during that time, we at the university will not market this to anybody else. We're going to stand still. So it gives you an opportunity to maybe work on a business plan, work on a business model, talk to us, find resources for how we can finance the company, all sorts of things. And then at the end of that period, if you've decided that you do want to move forward and you can sort of justify to us that this makes good business sense, we will enter into a license agreement with you. Generally, it's going to be an exclusive negotiable in an agreement when we work with the industry, for example, are there's a license fee that takes place right at the beginning. There's the reimbursement of patent costs. There's a royalty on sales. And then generally we're going to add milestones in, so technical milestones and financial milestones. And this is just to ensure that the technology is moving, right? So that, for example, a big company doesn't license something and then just put it on the shelf and they never develop it. So with startup companies, we try, as I said, to give a favorable deal. So, oh, and then there's an equity piece as well. With startup companies, often we will take a piece of equity in your company and maybe in exchange for one of those other items that I talked about. So there's a lot of negotiation that can happen, and we want to make sure that your startup can be successful, because if you're successful, then we're successful. So that's one of our prime motivations for giving you a good deal. But lots of negotiation happens there. I would say no deal is the same. You know, if you've seen one deal, they're always different. So this is a part that you would spend a lot of time on in your office with. And we always advise at this point that you get legal counsel. You know, the university, if we're doing an equity deal, we will hire an attorney that we work with quite often to negotiate that, because they're very complex. And so we would advise to you that you do the same. Some of the company formation and stuff you can maybe do on your own, but as Rhett said, I think it's really critical that you get an attorney in there. So that's all I have for today. We just, again, really appreciate you coming. We're excited to see so many people interested in startup companies, and I'd be happy to take some questions. Yes?
So if somebody has a great idea which involves the steps, and so each of those steps is a why. So do you suggest the person should initiate the process from the first step, or should he just wait until the final step?
So I'm going to always advise. Yep. So this question is about, you know, if you have this idea, but it's probably, and I think I have this right, it's probably a ways away from maybe even a patent filing. It's pretty early. So at what point should he interact and engage with us? And I'm always going to say just as early as you want, as early as possible. It might not be ready for patenting, and you know, like I said, don't take it personal, and be prepared to get no a couple times maybe before it is ready. But hopefully we can help you in trying to figure out what exactly you would need to get it to a point where we could move forward with it. So we're happy to talk to you at any point. It's early in your research. You know, if you've just come on as a faculty member, not faculty, but any part of the university, and you have an idea early on, we can maybe help you understanding what the prior art landscape looks like, for example, so that you don't invest a lot of time and resources in something that's already been done, or how you might do something different. We might have some suggestions on what we think industry is looking for. So I would say early on is better. Yeah.
And if it happens, the part of work is already published in the paper, then
It does, yeah. Yeah, publication always affects patentability. So in the United States, you have 1 year from the time you publish to file a patent application. And in most other foreign countries, you don't have any leeway. So once you publish, you lose the ability to patent. So very
important. Does it mean that
important.
someone is good patent or innovation from another country? I mean, outside the U.S., someone could patent or
So once it's published anywhere, it will act as a bar in foreign countries. Yeah. Once it's published in a foreign country here, it's basically the first to file. So the first person who gets to the patent office wins in the U.S. and every other country. So publication is a big deal, and it's a really rough road, right? Because for researchers and publication writing, and for patenting, publication can kill, right? I mean, so yeah, it's a fine line. So we always suggest you come and talk to us earlier. Yeah.
There are two questions. One is that if NUtech has not to file patent on one technology, does the faculty have the right to pay themselves and start patterns.
Yeah. So we are refining our process around this because.
Question? What's the question?
Okay, so his question is, if we decline to pursue something, does the inventor have the right to pursue it on their own? Like, can we work on a donation? And it used to be that we tried really hard to return inventions to the inventors to do something with it on their own. We're finding that that's very complicated, and especially if there's any federal funding to touch it, it requires going to the federal agency and trying to get a waiver. Oftentimes they're not willing to do it. But it also means you have a lot of obligations to the federal agency that make us a little nervous because we know that it's just a lot of work. So we're refining our process on that. In general, if we can, we would like to give you the technology back, but it's not always possible. So.
The question is, does all the faculty need to like get permission from NUtech when they have startup? If startup or not, depending on certain patents, can they just start a company without involving the NUtech?
So if it's completely outside the scope of your university employment and research, then yes. But at that point, then you're going to want to probably talk with conflict of interest, just to make sure that the time allocation and the idea is different enough. Yeah.
So maybe one more question, and then we can go on break.
Oh gosh, okay. I'll go here because I think you were first.
A simple question.
Yes.
So you filed your patent, you have your patent, so you have your intellectual property. Okay. At that point, we can let you license the agreement, market it somewhere. We can just sit back and collect our 33% and go on vacation, or we can decide to do it ourselves and go to the startup company and negotiate an agreement with you and maybe ultimately get better payback on that. Is that correct?
So maybe. I would say for the first case, you can sit back and let us license. The one caveat to that is that a company is almost always going to want to work with you in some capacity, at least to understand more about the technology. So there would be some commitment probably, depending on the technology. But a startup, I don't know the name, a startup can be a better deal. It can also, be a really tough, hard road before you would ever see that. So, yes.
It's all really a numbers game, though, in some sense, because I don't know what the current numbers are, but it used to be 1 in 10 startups are going to make it, or maybe 3 in 20, I don't know, something like that. Similarly, I've seen surveys of, like 13,000 university technologies, and you're batting pretty well if 10 to 15 to 20% of those are licensed. So there's a lot of stuff that doesn't get licensed right away, and unfortunately it's a very long timeline to get licensed sometimes, and then it's even a little bit longer to get to income. So
what proportion of the things that get licensed get to income? Very ballpark, half, 5%?
the things that get licensed get to income?
Yeah.
Most of the things that get licensed get to income.
Okay, so they back.
It may not be a lot.
Yeah.